the National Student Symposium last week, where the Georgetown chapter not only won Chapter of the Year, but also won debate championships, I'm sure in no small part due to this amazing series. Let's give ourselves a round of applause. Really would not have been possible without all of you, our board, our members, our students. Just a huge honor. We're the first chapter to ever win 2 awards in the same night. So it was a good night for all involved and a good night for Georgetown. This series is dedicated to Daniel Webster, one of our nation's most revered orators and public servants. Webster relied on the strength of his ideas to advance the American people's liberty and prosperity. He is rightly remembered as the great expounder and defender of the Constitution. Our resolution tonight is, should Americans embrace common good originalism? Whether such a constitutional approach mangles our law or orients it toward the things that really matter, we will leave for our speakers to contest. All I know is that hearing this conversation will be good for us students right here at Georgetown Law. To moderate this important debate, it is our incredible honor to welcome Chief Judge William H. Pryor, Jr. of the United States Court of Appeals to the 11th Circuit. We are likewise thrilled to host Mr. Thomas Berry, Director of the Cato Institute, Robert A. Levy Center for Constitutional Studies, and Mr. Josh Hammer, Senior Counsel for the Article 3 Project and Senior Editor-at-Large for Newsweek. Mr. Hammer is returning for his second Daniel Webster debate. You've all already seen his remarkable rhetorical gifts and fire. These are blockbuster, first-rate speakers, and it should be an excellent discussion. We're deeply grateful to the Federalist Society and to the Georgetown Law University for making the Daniel Webster debate series a reality. I now recognize our wonderful Vice President, Mr. Drew Benson, to introduce these 3 stellar panelists. Please give them a warm welcome.
William H. Pryor, Jr. serves as Chief Circuit Judge on the United States Court of Appeals for the 11th Circuit. During his time on the bench, he served on the United States Sentencing Commission, and in 2017 to 18 served as acting chair of the commission. He served as the 45th Attorney General from 1997 to 2004. When he took office, he was the youngest Attorney General in the nation. He graduated magna cum laude from Tulane Law School, where he finished first in the common law curriculum and was editor-in-chief of the Tulane Law Review. He then served as a law clerk for Judge John Minor Wisdom of the U.S. Court of Appeals for the 5th Circuit. His written publications have also featured in leading law reviews, including the Yale Law Journal, Columbia Law Review, Virginia Law Review, and many others. Chief Judge Pryor is a member of the Tulane Law School Hall of Fame and has received, among other awards, the Defender of the Constitution Award from the Heritage Foundation. Josh Hammer is currently Senior Counsel for the Article 3 Project and the Internet Accountability Project. He is the Senior Editor-at-Large of Newsweek, where he hosts the Josh Hammer Show podcast. And Mr. Hammer is also a research fellow with the Edmund Burke Foundation and a fellow with the Palm Beach Freedom Institute. Mr. Hammer is a college campus speaker through Intercollegiate Studies Institute and Young America's Foundation, as well as a law school campus speaker through the Federalist Society. Prior to Newsweek and the Daily Wire, where he was an editor, Mr. Hammer worked at the law firm of Kirkland and Ellis and clerked for the Honorable James C. Ho on the 5th Circuit. Mr. Hammer has also served as the John Marshall Fellow with the Claremont Institute and a Fellow with the James Wilson Institute. He graduated from Duke University, where he majored in economics, and from the University of Chicago Law School. Thomas Berry is the director of the Cato Institute's Robert A. Levy Center for Constitutional Studies and editor-in-chief of the Cato Supreme Court Review. Before joining Cato, he was an attorney at the Pacific Legal Foundation and clerked for Judge E. Grady Jolly of the United States Court of Appeals for the 5th Circuit. Mr. Berry's areas of interest include the separation of powers, executive branch appointments, and First Amendment freedom of speech. Mr. Berry has testified on the Appointments Clause before a subcommittee of the U.S. Senate, and his work on the Vacancies Act has been cited by the United States District Court for the District of Columbia. He holds a JD from Stanford Law School, where he was a senior editor on the Stanford Law and Policy Review, and a Bradley Fellow at the Stanford Constitutional Law Center. He graduated with a BA in Liberal Arts from St. John's College, Santa Fe. So with that, I'm going to turn it over to our panelists. Let's give them one more welcome.
Good evening.
Josh. Is Josh all set? Or not yet?
Yeah, Josh. I think we're starting.
Okay.
Good evening. Welcome, everybody. And thank you for inviting me. Thank you for hosting this debate. It's something I've been looking forward to today. In 1985, 40 years ago, Justice William Brennan spoke at a conference at this law school and responded to a speech that Attorney General Edwin Meese delivered earlier that year to the American Bar Association. Meese advocated a restoration of a jurisprudence of original intention in constitutional interpretation. But Justice Brennan lambasted originalism as, quote, little more than arrogance cloaked as humility. Brennan argued that what mattered was what the words of the text mean in our time. And he maintained that the Constitution required judges to strive toward the goal of human dignity. Of course, it was not the founder's conception of human dignity that Justice Brennan sought to advance. Justice Brennan made clear that it was a particular vision of human dignity that the Constitution should guarantee. For example, he argued that capital punishment was a violation of human dignity, and so unconstitutional, even though he acknowledged that most of his colleagues and most Americans disagreed. I will let you decide, as between Justice Brennan's methodology and the methodology he condemned, which of the two is better described as arrogance cloaked as humility. And so began what the Federalist Society would later call the Great Debate about originalism versus living constitutionalism. Attorney General Meese that same year responded to Justice Brennan in a speech to the Federalist Society, where he quoted Justice Joseph Story, quote, the first and fundamental rule in the interpretation of all instruments is to construe them according to the sense of the terms and the intention of the parties, end quote. He quoted James Madison, who argued that if, quote, the sense in which the Constitution was accepted and ratified by the nation be not the guide in expounding it, there can be no security for a consistent and stable, more than for a faithful exercise of its powers, end quote. And Thomas Jefferson, quote, our peculiar security is in the possession of a written constitution. Let us not make it a blank paper by construction, end quote. Now, Meese explained that originalism was a jurisprudence that seeks fidelity to the Constitution, not a jurisprudence of political results. He maintained it is very much concerned with process, and it is a jurisprudence that in our day seeks to depoliticize the law. After the debate between Attorney General Meese and Justice Brennan, the proponents of originalism multiplied. Justice Antonin Scalia became the leading evangelist for originalism, and Justice Clarence Thomas became its leading practitioner. 4 decades later, originalism has been restored as the primary interpretive philosophy of the judiciary. Today, most of the justices of the Supreme Court are originalists. They maintain that the text of the Constitution has a fixed meaning, that the Constitution means now what it originally meant, and that the original meaning is binding on them as judges. Despite that achievement, a few individuals on the right side of the political spectrum have recently condemned originalism. They advocate a kind of result-oriented jurisprudence indistinguishable in everything but name from Justice Brennan's living constitutionalism, so-called common good constitutionalism, or what I would call living common goodism. Now, its main proponent is Harvard law professor Adrian Vermeule, who argues that this approach takes as its starting point substantive moral principles that conduce to the common good, principles that judges should read into the majestic generalities and ambiguities of the written Constitution. Replace common good with human dignity, and Vermeule's living common goodism sounds a lot like Brennan's living constitutionalism. Now, contrary to what advocates of this approach argue, originalism is not a morally empty jurisprudence. Originalism demands respect for the moral perspective of the founding generation that ratified our Constitution and for the succeeding generations that amended it. Our country's foremost philosopher of natural law, Professor Robert George, has stated, "The fabric and theory of our Constitution embodies our founders' belief in natural law and natural rights." That perspective was reflected first in the Declaration of Independence when they asserted their right to self-government, the right of one people to assume among the powers of the earth the separate and equal station to which the laws of nature and of nature's God entitled it, and their understanding that all men are created equal, that they are endowed by their Creator with certain unalienable rights. It was reflected in the preamble to the Constitution, where we the people sought to establish justice and to secure the blessings of liberty. But respecting that moral perspective does not mean that federal judges have general authority to use natural law to achieve conservative political results. The founder's moral perspective essentially matters to an originalist when interpreting, especially matters to an originalist when interpreting the Bill of Rights. The founding generation understood those rights, for example, the free exercise of religion, the freedom of speech and of the press, the right to assemble, and the right to keep and bear arms for self-defense, to be what Patrick Henry called the rights of human nature. And they understood that an individual could not exercise a natural right in a way that would violate another's natural rights. They distinguished liberty from license. They understood liberty to be the freedom to do what is morally right. As Professor George has explained, the American founders were firm believers in natural law and sought to craft a constitution that would conform to its requirements and as they understood them and embody its basic principles for the design of a just political order. Now, I can only give a judge's perspective tonight as I introduce this topic. The Constitution does not give me as a judge the power to read into the text of the Constitution substantive moral principles that conduce to the common good. And fashioning that kind of jurisprudence would conflict with natural law. When courts exceed their jurisdiction and usurp legislative authority, whether for good or bad causes, they violate the rule of law by seizing power authoritatively allocated by the framers and ratifiers of the Constitution to other branches of government. Within the bounds of the constraints it imposes, the natural law is neutral about the kind of constitution that a people can establish to promote the common good. Like the ancient moral philosophers, the founders understood that power corrupts. They gave the judiciary limited powers for protecting the common good. They recognized the natural law itself does not settle the question whether it falls ultimately to the legislature or the judiciary in any particular polity to ensure that the positive law conforms to natural law and respects natural rights. So the question for judges is the scope of our power under our Constitution, which refers to itself as a written text situated at a fixed time in history. The preamble identifies our Constitution with the written text. The people, quote, ordained and established this Constitution for the United States of America, end quote. Article 2 declares that, quote, no person except a natural born citizen or a citizen of the United States at the time of the adoption of this Constitution shall be eligible to the office of president, end quote. Article 3 extends, quote, the judicial power to all cases in law and equity arising under this Constitution, end quote, as distinguished from other distinct bodies of law, federal statutory law, and treaties. Article 6, likewise, distinguishes, quote, this Constitution from the rest of the law that composes the supreme law of the land. And it requires that judicial officers be bound by oath to support this Constitution. That oath establishes that judges have a moral duty to obey the written Constitution, and one obeys the written text only if one applies its meaning. Applying what it does not mean would be to fail to obey it. There is no necessary connection between the meaning of a written text and the natural law or the common good. That is why we can know that a written text is a bad policy. The original Constitution, after all, it counted enslaved persons for apportionment purposes by 3/5 purposes. Now, we wouldn't think that as being consistent necessarily with the common good or the natural law. So whether the text bears a particular meaning is an independent antecedent question for interpreters to answer, and the constitutional oath requires that judges apply the fixed meaning of the Constitution, even if doing so, in their view, works against the common good. Now, that's my perspective. That's a judge's perspective. To hear a different perspective, and a slightly different perspective from that has been advocated by Professor Vermeule, I'm going to turn it over to our friend Josh Hammer to talk about the approach he favors, what he calls common good originalism.
Okay, I think I'm unmuted. Can everyone hear me? Thumbs up, Judge, if you guys can hear me. Okay, all right, there we go.
Yes.
All right. Well, thank you to Georgetown FedSoc. I was just there in person a month and a half ago. I guess I'm subbing in for someone who had to drop out, so happy I can make this work, albeit virtually. You know, it's funny. I drink a lot of coffee. My wife makes fun of me for drinking too much coffee, and, you know, query whether that's a good or a bad thing. But I was grabbing a mug of coffee this morning without even thinking about it. I actually grabbed my Georgetown Federal Society FedSoc mug, which I think you guys gifted me the first time I did an event for your chapter. So, you know, here we are, two times the span of a month and a half. So great to be back here. I apologize to Chief Judge Pryor, who I've known for many years now, to not having the chance to rendezvous in person and talk all things SEC football. I very much
Roll
miss those
Tide,
days.
Josh.
Yes, roll Tide indeed. And to Tommy, who I haven't seen in a very long time, good to be with you here as well. So I normally do the common good originalism talk when I do this at Federal Society chapters. I normally take somewhere between 40 to 50 minutes. So I've basically been asked to give an extraordinarily condensed version in like 7 to 10 minutes. So I guess I will do the best I can. And because of that, I will probably end up speaking very quickly. And I apologize in advance for that. So the basic argument for what I refer to as common good originalism is essentially as follows. So, you know, we heard some of the history there from Chief Judge Pryor of the founding of the Federal Society and the founding of what we today refer to as originalism. Originalism, incidentally, is actually a neologism. As Professor Gary Lawson of Boston University School of Law pointed out to me when I did this event at BU FedSoc a little over a year ago, if you go to Westlaw or LexisNexis and you type in originalism and you set the date to prior to 1980, you will get precisely 0 hits because it is literally a neologism. On the other hand, it is true that, as my own former two-time law professor at U Chicago, Will Bode, has said, and he's correctly said, that they didn't call it originalism at the time of the founding because they just called it law. And there's any number of quotes to support that. There's this quote from James Madison, way towards the end of his life. He's living in Montpelier in 1830 something. It's you know, well past his fairly mediocre presidency, and he's writing a letter to an interlocutor who I cannot quite recall. And he says, I entirely concur in the proposition that the Constitution ought to be interpreted according to the meaning that it was given when it was ratified. And here's the key part. He says, in this sense alone, is it the legitimate Constitution? So I don't dispute any of this, which incidentally is part of the reason why I call my approach common good originalism, because I genuinely think of myself as an originalist, as someone who thinks that the meaning is fixed. In fact, when I first started responding to the aforementioned Professor Adrian Vermeule in part of these internecine debates back in 2020, that was kind of my first bone to pick with Professor Vermeule, is that it was not obvious to me that he believed in fixation thesis. He later took that back quite a bit, actually, in an April 2022 article for the Harvard Journal of Law and Public Policy, which, if memory serves, was actually written in direct response to a speech given by none other than Chief Judge William Pryor of the 11th Circuit. So Adrian has actually moved slightly closer to my stance, actually, I think, insofar as he now concedes the inevitability, perhaps the normative suitability, but at least the inevitability of fixation thesis there. But all of this, when we talk about what the law is, we're we're engaging here in somewhat of a circular reasoning here. And here's where the talk will get a little more interesting, because we are avoiding the most important question of what the law is. I mean, that literally is the most important question here, right? And we can start with the following assertion. Alexander Hamilton in Federalist number 31 begins his famous essay by saying, quote, "In disquisitions of every kind, there are certain primary truths or first principles upon which all subsequent reasonings must depend." So this notion of primary truths or first principles, we might think of as the whence we came, as kind of the moral foundations at the time that the Constitution was ratified. What are these anchoring truths? What are these primary principles? How can we identify them? On the other hand, that is kind of the whence we came half of the equation. On the other hand, I think is the equally important, arguably more important, where are we going? And here is where I like to mention to those of you who study Greek philosophy in college, you're likely familiar with Aristotle and the concept of telos. This is kind of the notion of teleology here. What is the substantive overarching orientation of a body of law? What is all of this legal edifice, this constitution, all statutes passed pursuant to thereto and so forth there? What is all of this ultimately oriented towards? And the key part for our purposes here is that it is, I would argue, and I do argue, that is the normative legitimacy of those two-pronged inquiry, whence we come, where we come from, and where are we going, aka the Aristotelian telos there. The normative legitimacy of that is what makes this worth respecting as law qua law in the first place. The alternative, which despite protestations to the contrary, does look indeed like legal positivism here. The alternative would be something closely approximating the Nuremberg trials, and this is a somewhat hyperbolic example, but it is nonetheless illustrative for our present purposes. So at the Nuremberg trials, when you had all the prosecutors there who were prosecuting the Nazi war criminals, pretty much to a T, they all said the exact same thing. They said, "What are you talking about? I was just following orders. I was just following orders." And when you take this notion that some of the early originalist luminaries, I call them sometimes cheekily the OG originalists. So when you take this notion of kind of this very strict, narrow four corners of the page approach that I also sometimes call four corners-ism can take you to a very, very bad place here. Anthony Scalia used to mock the idea that the Soviets had a constitution. He was mostly talking about the fact that they had a Bill of Rights and they had no structural separation of powers protections for individual liberty or whatnot there. But you could equally mock the Soviet Constitution or whatever legal edifice the Nazis purported to have there by noting that these are fundamentally evil regimes, that they are based on evil principles and they are oriented towards evil ends. But it is the legitimacy of the American constitutional order, the whence we came. This country was founded as an ecumenical biblical country, and the where we are headed parts, the telos of the American constitutional order. That is what makes this legitimate in the first place and worth respecting as law qua law, in contrast to whatever the Nazis were doing there that the people who were being prosecuted in Nuremberg were relying upon there. There has to be something more than the four corners of the page here is the point that I am indeed trying to make there. If you stick to this kind of risible four corners-ism, taken to its logical conclusion, you'll get to something called corpus linguistics, which some of you are probably familiar with, some of you are maybe not familiar with. Corpus linguistics, popularized by the former Utah Supreme Court Justice Tom Lee, wonderful patriot, great man, older brother of Senator Michael Lee of Utah. I strongly disagree with his use of corpus linguistics, and I'm not saying that every four corners-ist legal positivist would endorse corpus linguistics, but I do submit that it is four corners-ism taken to its logical conclusion. Corpus linguistics is a software program, basically an algorithm where you put into the algorithm what is the term you're trying to identify, in what jurisdiction, what locality, what is the year. The dictionary will then figure out what dictionaries were in disproportionate use. It will hierarchically rank them and spit out to you the notion as to what the most likely definition was. And my problem with corpus linguistics in a nutshell is that we have just totally lost sight of everything that I've been talking about here. We have lost sight of this all-important two-part inquiry, the whence we came and teleologically where are we going conception that makes this worth respecting as law qua law in the first place. In many ways, this is kind of, we might say, the intellectually and morally lazy outsourcing of the very faculties that make us human in the first place to computer software programs and machines. It also oftentimes will run the risk of just nakedly farcical, overly literalist interpretations. So when I was at Georgetown FedSoc a month and a half ago, I was debating the Bostock case. The Bostock case, statutory, not constitutional case, but that is, of course, a very prominent example of how just an interpretive act entirely unmoored of this two-part whence we came, where are we going inquiry can start to go off the rails really quickly here. So the basic common good originalist assertion is twofold. One is for basic reasons of Burkean epistemological humility, because I'm an admirer of M. and Burke, if nothing else there. I would submit to you that many originalist theorists and practitioners alike tend to oversell the ease with which we can readily identify the one true, absolutely correct meaning of a term. It's not always as easy as kind of cracking open the dictionary, doing corpus linguistics analysis, and we should be a little more intellectually humble and frankly just candid about that fact there. So from that starting place where you're going to have a slightly larger, call it the construction zone to kind of use the nomenclature of various clauses in the constitutional text there, the relevant question then is what do you do? And my claim here is that when you are dealing with a situation where there are multiple historically plausible, non-frivolous possible interpretations of a legal text, that you should err on the side of this two-pronged whence we come, aka, in my estimation, my reading of the American founding, ecumenical biblical principles, and where are we going? This is kind of this notion of teleology here. Where do I root the teleology of the American constitutional order? Well, Judge Pryor mentioned it. It's actually right there in the preamble of the Constitution. Quote, "We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America." A few very quick observations. I'll give a concrete example, and then I'm done here.
Josh, we've got a few minutes.
Okay.
Let's can you do it in two?
Okay, 2 minutes. All right. So the ends here that you see are oriented towards not atomism or maximal individualism. They are oriented towards this notion of the common good, more perfect union, common defense, general welfare, and so forth there. So the basic claim is that when you are in kind of a construction zone, that you err on a reading that favors the telos of the American constitutional order, because the normative legitimacy of that telos is what makes this respecting as law qua law, not succumbing to the Nazi Nuremberg example there. Very quick, concrete example. 2011 case, Snyder versus Phelps. Phelps is the former head of the Westboro Baptist Church, very bad man. He passed away in 2015 or so, not a huge loss for humanity. Snyder is a man who served in a war overseas in Iraq or Afghanistan. He was slain. His family is laying him to rest at Arlington National Cemetery there. So you get to this military funeral, you have the stars, you have the bugler, it's the military, and Phelps, Westboro Baptist Church guy, goes to a public sidewalk and says horrific things, as they had a tendency to do there. So the family sues on an IIED, intentional infliction of emotional distress, tort claim, and as the case gets to the Supreme Court, is this a First Amendment protected act of speech that would have the effect of precluding the filing of this civil IIED tort claim? By an 8-1 count, the court says yes, because they are exalting the relativistic procedural wonders of the fact that Phelps is spitting particles out of his mouth there. In a heroic and courageous solo dissent, Sam Alito says no, because what is the actual purpose? What does he tell us of a regime of free speech? Is it to exalt the idiosyncratic fetishes of any single individual who is saying something? No. The purpose of a regime of free speech, going all the way back to Socrates in the Academy, is to pursue truth. That is the purpose of a regime of free speech. Therefore, this falls outside of the confines of the First Amendment. It is so desecratory of the military, the nation, the colors, and so forth there. Therefore, this IIED tort claim can proceed. That is a very quick and dirty example as to how common good originalism, aka the Alito position, can get you to a slightly different result as the all-out positivist procedural approach taken by the 8 justices in the majority.
Okay, thank you. So given the length of Josh's presentation, I'm going to give Mr. Berry 10 minutes.
Well, thank you very much. I don't know if I'll use all of that, but I appreciate it. And it is good to see you as well, Josh, even if virtually. Josh and I go all the way back to 2018 when we were in a 1-week seminar together where I was the one token libertarian in a group of 12. So I'm used to defending my lonely idiosyncratic positions, at least in some crowds. And Josh was a good interlocutor there, and I'm not surprised at all to have seen him become a famous pundit, even more famous than he was then. I'm in the process right now of interviewing next year's legal associates at Cato, and one of the things I asked them, these are recent law school grads, is what's an example of an issue where your view of the Constitution differs from your view of what good policy would be. And the reason I ask that is that if they can't name a single thing, then I feel like they don't really have a legal interpretation. They have political views, or to some extent, they might be starting with political views and then reasoning backwards to reach an interpretation that fits all of those political views. So I read as much as I could have that Josh has written on this issue as in the lead up to this debate in the last couple of days. And I have to say, you know, a lot of my remarks will just be questions for him that I genuinely would be interested in the answer, because I really don't want to accidentally straw man. And one of the first things I started with uncertainty is this based on purely just his view of the best history of what the principles were that the founders had, what their background presumptions of common good meant in 1787, 1789, and that just so happens to align most or all of the time with current conservative Republican policy views. If that's his view, then that's somewhat defensible. That's in a way a form of originalism, where you say there's a background tie-breaking principle that comes from natural, but it doesn't come from any higher order. It comes from the fact that that's what common good was understood to mean. But if that's purely his view, and that's the only reason why he's sort of arguing that this is the tiebreaker, you'd think that there would be at least a couple instances where that differs from the current conservative Republican view of the best policy outcome. So I'd be curious if we can name one or two examples where it does diverge. It seems pretty, the other option, which sometimes his writings seem to come close to it, but again, I'm not sure if this is his current view, is that it really is just indeterminate. Some questions don't have an answer, even when you go through all the tiebreakers, like all of the things that are baked into the original Constitution, and that when you have exhausted all the tiebreakers, a judge should then, as the final resort, resort to their own policy view of what is best, and that we should appoint judges who have conservative Republican policy views, and so long as the majority of judges and justices have conservative Republican policy views, it's fine and good for them, within the bounds of only tiebreakers, to do that. Then the outcome would always be conservative Republican policy views, but in my view, that's a lot harder to defend on principle, because then you're kind of admitting that this boils down to a political clash, that within however big or narrow that realm of indeterminacy is, it turns into politics. And we just have to hope, or conservatives just have to hope, that they keep a majority of conservatives on the court, which I don't think, maybe some are confident they will. I think that's less determinant and less certain than they may think. So that's my current first concern. I would say then, to the extent it's a historical debate, I think Josh puts too much weight on just the preamble and doesn't do enough work into each individual clause of the Constitution separately. So even if that's the most general background presumption, and even if I spot him that common good had some notions of Judeo-Christian values, what have you, would that really overrule, or would that be more important than specific evidence we have for the meaning or the philosophy behind individual provisions of the Constitution, most notably the 14th Amendment, which obviously was enacted in the 1860s, not the 1780s. And your own professor on the faculty here, Randy Barnett, along with Evan Bernick, has written an extensive, very long, and very well-researched book just about the original understood meaning of the 14th Amendment. And to some extent, that also comes with baked in, that they have found that, for example, the understood meaning of privileges or immunities at the time had a lot of substantive meaning to it. And I think that's plausible. And you could accuse that of being somewhat libertarian, but it's not libertarian on every single view. It doesn't cash out 100% that way. And they back it up with specific examples, things like the Coreyfield opinion that was very influential at the time. And so if you have a question of how to interpret the 14th Amendment, should you put more weight into that specific background for the 14th Amendment, or the more general, more conservative Judeo-Christian, whatever history you have about the preamble? I think the specific has to govern the general as well. I would say Josh makes an interesting broader point about like strict textualism versus maybe you might call it intentionalism or background principles. And I think that's actually well taken. And I think even some originalists and textualists might be moving a little bit closer in that direction. Again, in Randy Barnett's book, he not so much renounces, but adjusts some of his prior view that intent doesn't matter at all, and says, no, you can to some extent by looking at the text itself, see what its purpose was. Kind of like looking at a watch, you can somewhat tell what the watchmaker was trying to achieve, and that it's okay so long as you find that purpose within either the text or publicly available documents that the general public would have known, it's okay to have that kind of intentionalism in there. So I'm not opposed to the notion that that kind of intentionalism could be found if you did a historical analysis at the time of the framing. If he can give hard evidence that that kind of intentionalism, again, embodied conservative Republican values. I'm not seeing it so far in a phrase as generic as common good, but I think that's really for historians to fight over. But once again, I think even if we give him that point, that pure literalist textualism isn't the way to go and you need to be a little bit broader, you still have to then say, well, what doesn't that apply equally to the purposes behind each individual provision in the Constitution? And then, I would say if take that one step further to textualism or to statutes, a large part of this project seems to have been prompted by Josh's viscerally negative reaction to the Bostock opinion, and that's fine. I mean, textualists disagreed on that. You have the Gorsuch opinion, but you have a Kavanaugh dissent, and I think they're both very plausible textualist approaches. But even if you side with the Kavanaugh dissent for that particular statute, if you say that Gorsuch was wrong because he was too hyper-literalist and didn't think about the intent or the purpose of those making the statutes, that approach is not always going to cash out in conservative policy outcomes. If a statute was drafted or passed by people with more progressive policy goals, then the same sort of approach Josh is saying, don't be so hyper-literalist, would cash out in more progressive policy outcomes. And I'm not sure, but maybe he is, but I'm not sure he's willing to swallow that consequence. So I'm thinking, for example, of the King v. Burwell case. This was big when I was in law school. Maybe it's before your all's time, but this was a challenge to Obamacare that essentially was an attempted gotcha, if I'm being frank. There was confusing language in the statute that arguably meant that an important provision didn't apply to exchanges that had been established in certain ways that would have really undercut Obamacare in a major way. And so a challenge was brought. Chief Justice Roberts says, no, we're not going to interpret hyper-literalist. We're going to interpret it based on the purpose of this law, which was to, create a new reform of the medical system, the insurance system in this country, not to destroy it. And he was kind of lambasted for that, but I feel like to some extent, that's the more intentionalist, purposivist approach, not a four corners approach that Josh is suggesting we should have applied in Bostock and we should apply in other interpretive endeavors. So I would just posit that if that is his broader general interpretive argument, you're not going to get a conservative Republican result for every single statute. And I'll stop there.
Should I respond, Judge, or do you want
Yeah,
to take it?
it's your turn, Sean.
Oh, okay, got it. Okay, how much time do I have? Just 'cause I don't want to go too.
Well, the plan was 2 minutes. But
Okay, all right, that's fine. All right, maybe it's fine. I don't know. A lot in there to respond to. Obviously, I'll try to just kind of pick out some snippets because I really can't do it full justice in 2 minutes. There obviously are some times where I think that the only correct plausible interpretation cuts against my policy preferences. The example I typically like to use when this question inevitably gets asked is the Gonzalez versus Reich case. That's the drug case that your own law professor, Randy Barnett, was actually very instrumental as a lawyer on at the time there. This is the case in California where some guy is growing medical marijuana in his own backyard solely for his own for his own use, and it ends up getting litigated all the way on Commerce Clause and Necessary and Proper Clause grounds. Is this illegal under the Controlled Substances Act, Wickard versus Filburn, and all of that there? And, there simply is, I think, no intellectually honest answer other than the fact that the Constitution simply cannot cover a marketplace of one individual. To do otherwise would be to give the federal government plenary police powers. And that is just obviously a complete inversion of our entire constitutional structure. My policy preferences are that I'm a hardcore war on drugs guy. If I were monarch, I would eviscerate all these things by snapping my fingers basically tomorrow. So that's one example. There are any number of other examples as well. Another point that I like to make is that I readily concede that the vast majority of constitutional provisions are extraordinarily easy. So actually, one area where Professor Vermeule and I actually disagree, well, he actually disagrees on Gonzalez versus Reich as well with me. But another one where we disagree would be the Second Amendment. So the Second Amendment has an interesting prefatory clause, right? The Second Amendment reads, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." Professor Vermeule, who interprets the text, he claims it's fixed, but if it's fixed, then it's at an extraordinarily high level of abstraction at minimum there. He puts a lot of weight on the prefatory clause, and he then says that DC versus Heller, the 2008 case, was wrongly decided. From my perspective, the prefatory clause is interesting, but it simply cannot, on intellectually honest grounds, get around the sheer force of the phrase right of the people, which simply must have the same meaning in the Second Amendment as it has in all the other amendments in the Bill of Rights. So there's a lot else to get there, but for purposes of time, Judge, I'll stop there, I suppose.
Okay. Mr. Barry.
Sure, that's helpful, and I appreciate the example of the Raich case. I think that's a good example, and it's important that you do have specific, cases where it doesn't cash out in the same way. I guess I'll just add that another concern of mine, we can argue, you bring up the First Amendment in some of your articles. You brought up the Snyder versus Phelps case here, and again, you say, oh, what's the value in this speech? One of my big concerns is, are we moving? There are two arguments. One is just an originalist argument that the legislature should have more leeway to regulate speech as they think is in the common good. And that's a legitimately defensible view of the history. Professor Judd Campbell, who you cite, understandably, has written very interesting history about the First Amendment, saying it wasn't as absolutist. And I think libertarians and free speech absolutists need to grapple with that and take it seriously. I'm not 100% convinced, because I think, for example, the 14th Amendment history matters to that as well. But yeah, at the framing there, it does seem that legislatures were given more leeway. But then the key question is, were they given more leeway for their view of the common good, or for just one sort of substantive view of the common good? And are we only going to align, or does Josh think it should only align with that sort of Judeo-Christian value, common good, whatever substantive things he thinks are baked into there? So I'd just give one example that occurred to me is if the First Amendment became less absolutist, some conservative states might ban flag burning. Some more progressive states might ban displays of the Confederate flag. And you could say either they could make their arguments that either of those supports the common good as they see it, that kind of speech is disruptive to civil order and not worth the candle, or whatever you want to say. And so they're going to make a policy judgment. If you want to say as an originalist matter that they have leeway to do both, that's defensible. But if you want to start having judges get into the business of weighing that and say, no, the real common good, the correct virtuous common good is patriotism is valuable. So we can ban flag burning, but we can't ban Confederate flags because that's a part of our history or whatever. Lots of possible arguments. Then again, you get into this, it really feels like judges are making policy choices. And I fear that you get into a realm where it feels like it's just a proxy war, again, between Republicans and Democrats, conservative and views. And practically speaking, that is only to the benefit of people on Josh's side, so long as they have a majority. Whereas if you have a much stricter view, then you just don't open the door to either of those types of regulations.
Okay. Let me ask some questions for each of you. And I'm going to have questions to begin with for each of you that are related, that get to different points for each of you because of your perspective. So in the Reagan administration, when the Department of Justice and White House counsel's office would interview prospective nominees, they generally would not ask them about specific Supreme Court precedents. They would ask them instead about the potential judges' approach to the Constitution and how they would go about the task of judging in a methodological sense. So if you're interviewing judicial nominees, Josh, and originalism is just not enough, it needs a qualifier, common good originalism. How do you weed out the Nazi? So you talked about the danger, a positive approach leading to Nazi consequences. I've never really thought that there was any provision of the Constitution that in my job as a judge, if I interpreted it faithfully, it would lead to a Nazi result. But if originalism is to be qualified by the judge's own conception of the common good, or their own sense of where it is we begin and where it is that we're going, how do you root out with that from the qualifier, the Nazi?
Okay, interesting question, Judge. Expected from a man of your prestige and intellect, I suppose. So there are a number of things that I have publicly written that I would look for when it comes to vetting judicial nominees. Some of them have to do with what you're getting at. Some of them are maybe closely adjacent to it. I've actually been very explicit, and this is not directly on topic, but it's kind of related, I suppose, that I actually care about a judicial nominee's private life a lot. I care a lot about the so-called spouse test. I really care about who your wife is or who your husband is. I think it is actually no accident that Martha Anilito and Ginny Thomas are two rock-ribbed women, and that their two husbands are the two most rock-ribbed justices. And on a closely related point here, talking about trying to make sure that a judicial nominee kind of has this sound conception of kind of the underlying principles of the American founding, I actually want to know where you go to pray. I actually genuinely care if you go to a house of worship, and specifically, I want to know that you go to a theologically conservative house of worship. The well-documented rumor was that Justice Gorsuch was a frequent attendee at a rainbow flag style theologically liberal church, and I think it is probably no accident that this is also the man who gave us the Bostock opinion there. So I actually care whether or not you're going to a Torah observant synagogue, a God-fearing church, Bible-believing church. So these are the kind of things that I actually would look for as well. I wouldn't necessarily ask the nominee, if I were in the White House counsel's office, are you a common good originalist? It would kind of be political suicide, frankly, for someone to publicly identify as that, for instance, on the Senate Judiciary Committee dais. I cannot foresee a situation in which a prospective nominee would say, Senator Cruz, Senator Lee, Senator Hawley, I am citing Josh Hammer, I'm a common good originalist. I'm not necessarily getting my hopes up for that there. Rather, I'm looking for kind of a strong indication that the nominee understands that biblical values really do undergird the American founding here. And I'm ultimately really caring about whether or not you understand that America was founded not as kind of this classical liberal Enlightenment bastion, but fundamentally, really, again, as kind of a common good undergirded biblical country. To give just one very clear example, you guys can see over my right shoulder here, shameless plug, my first book's coming out on Tuesday, Israel and Civilization, The Fate of the Jewish Nation, The Destiny of the West. I talk about the political philosophy of Hebrew scripture in here. And so for instance, and I'll stop after this, but in Exodus chapter 19, just to give one example there, God is revealing his word for the very first time at Mount Sinai. The mountain is hovering over Moses and the Israelites there. And the quid pro quo is that God says to the Israelites assembled, I shall make you a holy nation and a kingdom of priests. Note what he does not say. I will make all of you individually holy. It's this notion of kingdom, nation, of the whole, of the common good there. I genuinely do claim that the men who drafted the preamble, the men who led this country at the beginning, understood kind of intuitively. They understood intuitively that this was an experiment that was, yes, in ordered liberty, but fundamentally oriented towards kind of health of the whole, communitarian ends. So any kind of way that I can use as a proxy judge to try to inquire whether or not a nominee understands that, that's the kind of thing that I would do.
Right. All right, so Mr. Berry, my question for you is, if you're interviewing the judicial nominees, and how are you going to root out those who are faithful to the Constitution as opposed to just what your more libertarian perspective might desire to be the result in any given case? And, you know, you might want to tell us, what are your examples of a faithful application of the Constitution that does not lead to your favorite libertarian result?
Yeah, great question. And I think absolutely, everyone, me included, should have those. I would say that one, that since I joined Cato, is the Dormant Commerce Clause. I think Justice Thomas is also of this view. This is kind of the principle that a state cannot too much regulate national commerce as an inverse of the rule that's explicit in the text, that the federal government cannot regulate purely intrastate commerce within a single state. It's as a principle, as a policy matter, it would be great. I think if we had a rule that one big bully state like California can't pass a law that de facto changes the economy in 49 other states or forces them to go along with their regulations. But I think, a textualist approach, and Justice Thomas has made this argument, there's not a lot of evidence that's in there. It's taken from purely sort of, it's taken from silence and attempt at a logical inverse. We intentionally have not filed in favor of dormant commerce clause challenges since I sort of came to the view that there's not enough evidence to really justify it, or at least to be confident enough to strike down a law under that. I think also, again, I would say Judd Campbell's scholarship is prompting a lot of discussions among principled libertarians. I think that we are going to have to grapple with it and potentially move to a situation where we either give some more leeway to regulations of speech or look towards the history of the 1860s rather than the 1780s, if First Amendment absolutism really is correct. And I would say another one, well, I would say that, again, looking to Randy Barnett's book on the 14th Amendment, you again get to a point where there is some economic liberty baked into it, but it's not absolute. It again was limited to kind of specific factors set out in the Corfield opinion and some other specific factors. So I think I'm moving away from, one of Randy Barnett's early books had the subtitle "The Presumption of Liberty," and I think it's less at this point that you should have that presumption for everything, and more that you need to back it up with specific evidence on a clause by clause basis.
Okay. So I'm going to return to Josh for the follow-up about interviewing the judicial nominee. So, one of the problems with trying to figure out what the judge is going to do in the where we are going sense is that the Meese Justice Department, the reason they didn't want to ask about specific cases and they wanted to talk about method, and this is what they said at the time, was we don't know what the next potential Roe versus Wade or other kind of decision that departs from the original meaning of the Constitution will necessarily be, where there will be this temptation on the part of a judge. And what we need to know more is about how do they approach cases. How is your wife test and your church test going to help you with that?
Okay, so look, I mean, that was obviously an incomplete list of things that I would personally look for. There are other things that I would look for as well. Another thing that I care about a lot is your ready of willingness or eagerness to overturn flawed precedents. One of the big problems that we have from my perspective at the court over the past few years, frankly, over the past few decades, is that we have a lot of people who are not willing, able, and eager to actually use the tools at their disposal to overturn horrific precedent there. And this decision can come in any number of stages. So you can have the stage of not voting to grant cert in a case to begin with here. So I think back to the Arlene's Flowers case at a Washington State involving Baron L. Stutzman. Familiar story. It's not a bake the damn cake bigot case. It's a use your floral arrangement bigot case. This is in 2021. Justices Kavanaugh and Barrett vote against hearing cert there. Okay, so I want to know that you're going to be willing to get your hands dirty when it comes to actually voting for cert. Similarly, how about Article 3 standing? Well, we saw that actually last summer in the Murphy versus Missouri case. That was the horrific First Amendment big tech censorship case involving plaintiffs like Jay Bhattacharya there. What Judge Terry Doty in Judge Pryor's home state of Louisiana referred to as the most...
I'm an Alabamian.
Sorry. Yes, you're from Mobile. You went to college in Louisiana. My fault. Sorry about that. But Judge Terry Doty referred to this fact pattern as the most sprawling censorship regime in the history of the United States there, and you can go back and read the opinion for yourself there. Nonetheless, last summer, Justices Amy Coney Barrett and Kavanaugh yet again decided to punt this on Article 3 standing grounds over the vociferous protestation of Samuel Alito there. Stare decisis, I think, would be another instance here where you want to try to vet the nominee for an eagerness, a willingness to aggressively correct course, overturn flawed precedent. We're probably going to get a good example here in the next few months to potentially overturn the Humphreys executor case of 1935. Just to give one example here, this is the case involving so-called independent agencies and firing for cause. I would like to know whether or not a nominee's view of stare decisis would necessarily ipso facto preclude him or her from overturning a case simply by dint of the fact that it happened 90 years ago. So these are all sorts of things that I would look for as well. But Judge, I also care here. I've alluded to a lot about the fact that thus far that my view of America is not that of a classical liberal Enlightenment bastion. It fundamentally is that of a more communitarian, biblically based country there. And I genuinely would like to know how the nominee actually, really speaking at a very abstract level, what is your actual view of the founding of America? I mean, is it closer to Professor Barnett's view, where you have this kind of Jeffersonian, Lockean presumption of liberty? Or is your reading of the American founding closer to my view, where you recognize that, yes, the colonists cared about John Locke and the Second Treatise, but you know what they read a lot more than John Locke? The Bible. So I would like to actually know what the nominee's views as to the actual morality and political theory of the American founding were as well.
Okay. Let me ask you this. I've got to follow up with that. So as I understand it, for example, in the free exercise area alone, a lot of originalist scholars would say there were about 4 different strands of thought that informed the founding generation's perspective about that. How would you deal with that?
Well, I mean, I don't claim that the American founding was an intellectually homogenous exercise. I mean, obviously they were familiar with the Greeks and the Romans. They obviously had read their European Enlightenment liberals there. Rather, I am claiming that there is a general trajectory here. There was a general trajectory towards this notion of the common good. I mean, Judge, one of the first great debates at the time of the American founding was whether or not we would actually inherit the common law from England. I mean, you had kind of the Jeffersonian wing of the American founding, the more Francophilic pro-continental European branch that vociferously opposed it there. And then on the other hand, of course, you had John Jay and John Adams and this whole wing in the founding that argued in favor of the English common law. And we obviously ended up adopting the common law in all but the aforementioned state of Louisiana, which was a nightmare as a Fifth Circuit clerk, but that's neither here nor there for present purposes. But the common law, I mean, what is the English common law ultimately predicated on? Well, you can go back and look to people like John Fortescue, the godfather of Anglo-American conservatism, writing in the 14th century in a Latin-named book that is escaping me at this moment there. He says the Roman law is actually a tool for tyranny, but it's the Bible that we're actually basing this on. Justice Joseph Story in the 19th century famously said that Christianity itself was actually part of the English common law there. So you kind of look at that, you look at these broader communitarian, common good, dare I say, nationalist aims that are ingrained right there in the preamble, the most explicit teleological statement at the founding there, you can generally see a broader trajectory is all I'm basically trying to say.
Okay. Ms. Berry?
I think, again, this is a difficult area for any form of originalism, and it kind of gets to a broader picture of, so say you have evidence of both an original meaning of text, but also original views or views from that time about how to achieve the meaning in the text. So a concrete example is, again, from the 1860s, the 14th Amendment, equal protection. What did that mean at the time? A lot of evidence it meant racial equality. That's the most obvious purpose behind it. But what did they think counted as racial equality? They had segregated schools at the time. So many of the people who enacted that text thought at the time that racial equality was consistent with racially segregated schools. Does that I think most originalists now would draw a distinction between meaning at the time of the text and the way that they put that into application. Equality means what equality meant, but if they had mistaken views that segregation is consistent with equality, we're not stuck with that forever. New information and new understandings allows us to say, no, actually, it's impossible to achieve equality with segregation. I think similarly, Josh, you have to drill down a little bit into how much are we bound by the views at the founding about this common good. Did they view, I'll spot, Josh, the first question, which is, say the preamble has legal meaning. It's saying that at any point when you've run out of everything else, support the common good. Okay, fine. Even if that's true, are we also bound by the substantive views of the framers that the way to achieve the common good is with policies that further Judeo-Christian values, marriage between one man and one woman, name 100 other potential substantive things? Even if they also viewed that, I'm not convinced, I don't agree that originalists have to be bound by that. So I think, again, at best, we're left with you further that goal as best as the understanding is currently. And then you have the tricky thing of, okay, who decides how to further that? And it seems like Josh, again, if I take Josh's argument to be, no, we're just furthering the goals they had at the founding. But if that were true, it shouldn't really matter whether the judges we're nominating now are Christian or not. They would be bound by their oath regardless to take those original principles. But I think it's telling that Josh is only comfortable with judges who are in fact conservative Christians or Jews to carry that into effect, which kind of, in my view, blurs the lines between, is this about the judge's view of the common good now or what people thought the common good was at the founding?
Okay, it's 7 o'clock. We have 5 minutes left. That's enough time for closing statements. So they have to be quick. But Josh, 2 minutes for your closing and then 2 minutes for Mr. Berry.
Okay. Let's talk about 1858. In 1858, Abraham Lincoln and Stephen Douglas had their famous debates up and down the state of Illinois. And at the time, this was done, of course, in the context and the aftermath of the Dred Scott versus Sanford abomination the prior year in 1857 there. And in Dred Scott, the court infamously held in its worst opinion ever that Black people were not and could not ever be citizens of the United States. You go back and you look at the 1858 Lincoln-Douglas debates, and you actually try to read the transcripts there, you will see that even more so, arguably, than any substantive issue, they really were talking about the question of judicial power and legislative power, this notion of separation of powers in general. Stephen Douglas took what we might call the absolutist procedural position, where he said, who cares? Let's just do popular sovereignty in the Western territories. Leave it up to majoritarian vote and so forth there. But the reason that we remember Lincoln and not Douglas there is that Lincoln famously recognized 4 years prior in his Peoria, Illinois speech that the relevant moral question, and using his word at the time, not a word that we would say today, but the relevant question he said is whether or not the Negro is or is not a man. So what Lincoln did in short was he basically did an end around. He did an end around this, shall we say, positivism, this notion of the idiosyncratic individual liberty assertion. Recall that Dred Scott was actually the first time that substantive due process was ever invoked in a judicial opinion. They said that the slaveholder has a substantive due process, quote unquote, right to his slave there. But what the common good mentality implicitly does, whether or not it's explicitly resorting to the preamble, as I counsel current judges to do or not there, what the common good mentality kind of implicitly does, and what Lincoln understood, is that in a situation like this, where you have an idiosyncratic assertion of individual liberty on the one hand, and an overt moral calculation on the other hand. So for instance, here Lincoln understood that a house divided cannot stand. All these other things that he famously spoke about there. You should indeed err on the side of the common good, because it is this telos of the common good that makes our entire American constitutional order worth respecting as law qua law in the first place here. So for purposes, and I'll end on this, Judge, for purposes of judicial interpretation, we are talking here about close cases. I readily concede that most cases don't lend themselves to a neat Snyder versus Phelps style kind of common good originalism versus positivist originalism approach. We're talking here about very close cases there. It indeed should be something of a tiebreaker in a very close case, as opposed to simply deferring to the legislature as Stephen Douglas did. That seems to me to be a mistake.
Okay. Mr. Berry.
I guess I'll wrap up with my concern about the consequences of those, though I'll admit that this is ultimately a debate about interpretation and history, not consequences. But I think Josh had a good example of sort of, well, my view would have led to terrible consequences, did lead to terrible consequences in Dred Scott. I would say I can put forward more examples where judges deference to the current popular views of common good as a overriding individual rights has led to serious problems and is now in the ash bin of history. I mean, one is the many free speech cases from around World War I, when the fears of socialism or of draft dodging led the Supreme Court to essentially uphold prison sentences for people who were members of the Communist Party, who were members of the Socialist Party, who simply distributed pamphlets suggesting draft dodging. The infamous "Can't Shout Fire in a Crowded Theater" comes from a case called Schenck, which essentially upheld prison sentences for nothing more than advocating political views. I think this is now almost universally seen as a wrong turn, a serious wrong turn by the Supreme Court, that if it had continued would have allowed popular majorities to suppress unpopular political views in the name of national security. And it's good that we didn't go down that road, even though the vast majority of people at the time would have said the common good was to rally the troops, oppose socialism and communism, and support the war effort. Similarly, again, this is an obvious, maybe it's a cheap shot, but Japanese internment, can't not mention that, was a situation where common good, the war effort, the notions of national security overrides everything else, has to temporarily override individual liberty. So certainly examples can be brought out on both sides. But I would say in the long run, the main purpose we have for a constitution is to sometimes protect minorities against popular majorities' views of the common good. And you can't rely on that majority view to always be, in fact, in the common good.
Okay, well, I want to thank the audience tonight, and I want to thank Georgetown's Federalist Society chapter for hosting this debate. Please give the debaters your appreciation.
Thanks, everyone.